Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. President Trump's anti-DEI executive orders are back in full effect. On March 14th, the Fourth Circuit Court of Appeals lifted a nationwide injunction that a Maryland federal court issued last month on portions of President Trump's anti-DEI executive orders. This allows the administration to enforce the executive orders while future challenges proceed. Epstein Becker Green's Nathaniel Glasser tells us more about the ruling from the appeals court.
The Fourth Circuit decision is remarkable because it was accompanied by concurring opinions written by all three panel judges. With the preliminary injunction stayed, the executive branch may engage in full enforcement of the executive orders. There will be an ongoing legal battle over the constitutionality of the executive orders, but impacted organizations, and especially federal contractors, must be prepared to adapt and respond to changes in federal policy.
Epstein Becker Green's Frank Morris points out that this has major implications for federal contractors related to the False Claims Act.
The False Claims Act is a serious matter for federal contractors, and it's now clearly in the picture with the Fourth Circuit's action staying the injunction. This means that federal contractors who are performing services for the government or providing goods make a certification when they are going to submit their claims for payment that they are in compliance with all requirements. And now that the DEI requirements are in effect, this means that this could be the basis for a False Claims Act action that would be brought.
Frank also points out that contractors need to be aware of the added potential for whistleblower claims.
Employees can file a whistleblower claim. They'd be protected against retaliation as a result of that, and the financial consequences to federal contractors from a False Claims Act could be very substantial, particularly depending upon the amount of the activity that they perform on behalf of the federal government.
Finally, based on this ruling, what is the next step federal contractors should take?
A contractor really needs to now look to its policies and see whether or not they have anything that is going on, because the EEOC has put out guidance with the Department of Justice, and they've seized on the Supreme Court's decision a year ago in the Muldrow versus St. Louis case that some injury is all that is required, and they would define this as any employment decision that is in any way motivated, even in part, by illegal considerations, and by that they would mean considerations of race, sex, religion, national origin.
Thanks, Frank and Nathaniel, and thanks for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.